Rent control! When do we want it? Now!
The Fiscal Alliance Foundation is opposing a proposed ballot question that seeks to reintroduce a government-imposed rent control scheme in Massachusetts, reversing the public's decision in 1994 to outlaw the measure statewide. Massachusetts' ballot certification process under Article 48 of the Constitution includes a critical protection known as the Excluded Matters Clause, which prevents initiatives that constitute an uncompensated taking of private property. This is not a theoretical safeguard and has been successfully applied before the Massachusetts Supreme Judicial Court. Attorney Tad Heuer explains.
Here, the main argument is that 40P, the Massachusetts Rent Control Prohibition Act, is being repealed. And by repealing it, you're repealing its just compensation provision. Repealing a just compensation provision would seem antithetical to an individual's right to just compensation for their property. And because Article 48 doesn't allow ballot questions with such a provision in them, our argument is fairly straightforward in that respect. That the SJC shouldn't allow that to go forward, and the Attorney General shouldn't have allowed that to go forward. There are related arguments about the Just Compensation Clause because it has been raised in some SJC decisions previously. There was a decision about 25 or 30 years ago that involved compensation for bondholders of turnpike bonds. Essentially, the ballot question proposed to eliminate tolls on the Mass Pike. The bondholders challenged that, saying that's the security interest we have in our bonds, which is the toll revenue. And if you take away that revenue, you're also taking away our private property. And the SJC agreed. And they said, yes, this would constitute a taking of the private property of this secured interest. Here, we think that there's a very similar analogous argument in that every rental unit that's purchased in Massachusetts, as we know, rental units and any units are expensive in Massachusetts. So to buy one, you often need to go to the bank and you need to get a mortgage. When you get your mortgage, the bank will say to the landlord, how do you expect to pay me back? And usually you will say, well, it's a combination of whatever my down payment is, but also whatever rents I'm going to charge. And I believe that in whatever city I'm in, whether you're in Worcester or Fall River or Lowell or Cambridge, the market will sustain a rent of about this much per month for an apartment of this size. And I believe that given the demand for these apartments, that's going to increase. I'm going to be able to increase my rent reasonably at a market rate of, say, 6% a year or 7% a year. The bank will then say, right, if you think that you can charge this amount for these apartments and you think you can increase your rent 6 or 7% a year to be competitive with market rates, then we'll give you X number of dollars in order to buy that building. If you have rent control in effect, you may only be able to raise your rent, say, 3% a year. At that point, the income that the mortgage holder, the bank, is going to be able to secure is going to be much less because they were expecting and had signed the mortgage on the expectation that you'd be able to have a rent of 5, 6, 7%. What you're then doing, if you impose rent control, analogous to the turnpike bondholders, is that you're taking away some of that secured interest. They have a security interest, the mortgage holder has a security interest in the residential rental streams of income, in the same way that the bondholders had a secured interest in the revenue streams that were being derived from the Mass Pike toll revenues as to their bonds. Where the SJC said in that case that constituted a taking without just compensation and therefore violated the Excluded Matters Clause and therefore meant that the ballot question about Pike tolls couldn't be put on the ballot as a ballot question, we believe the same analysis applies here. So there are two different arguments, both of which we think are valid as to Article 48's Excluded Matters Clause. There's also a third argument, as we noted before, you can challenge the summary, right? And that's the summary that the voters will look at because they want to know what they're going to be voting to do. The Attorney General's summary in this case only says what the proponents are proposing to affirmatively do, which is to create a new rent control system. What the summary doesn't say is that in order to do that, they need to remove and strike the existing Rent Control Prohibition Act. And we think it's essential for any voter who's going to be voting on this to know what they're doing, that they're not just creating a new scheme, they're also eliminating an existing law that has existing protections for exactly these types of individuals, for landlords who have spent their money to buy a building on the belief that they'll be able to charge the rent sufficient in order to pay their mortgage, and all of a sudden that's being upended and it's being taken from them without any compensation being provided. And without a voter knowing that that right is going to be taken away, it's very hard to argue that the summary for that voter is fair.
The Fiscal Alliance Foundation is a nonpartisan nonprofit 501c3 organization. Visit our website to read more about our alternative energy policy studies, sign up for important email updates, make a tax-deductible contribution, and follow us on social media.